in-person conferences as they used to at times, or phone conferences. The executive director and the prosecuting AAG, if a statement of charges has been served, typically participate in these. And the consulting board member, a long time ago, I was the prosecuting AAG. At that time, the consulting board member did not participate in the settlement negotiations. I don't know if that's changed. But the consulting board member's authorization was needed, so we would try to have the person available by phone if different counter offers are being discussed, so that an agreement could be reached at that time. Is that pretty much still the practice, Charles?
I think we don't have a lot of CBM participation in the negotiation, although we have had CBM participation more recently in a particular rather complex case, just to kind of hear what's happening. But you're absolutely right. Yes, the negotiation is usually run by the staff, then run by the CBM.
All right, next slide. This is still about consent agreements. So the board has to take action approving these, and they're presented to the board, except the consulting board member is excluded, for approval, either at a meeting or an email voting context. And I think email voting is the default method used nowadays. And you'll see in those emails that any board member, if they have questions, they can consult Kirsten, or if they have legal questions, consult the board advisor. Or if they think it should be discussed by the full board because it's novel, unique, or confusing or something, they could always request to be placed on a meeting agenda, and Kirsten could either put it on, fit it into a board meeting, or maybe even set a special phone meeting or arrange something like that. So you have that option to request that. If it's disapproved, a revised consent agreement could be renegotiated and presented to the board again. So it's not just one chance at that. But if the board disapproves it and a revised agreement can't be reached, then it's time to go to the hearing. So next slide. So the pre-hearing conference is the first step. As I said, the APA applies, and there are also model rules of procedure in WAC that apply. The presiding officer is typically the board chair, unless the board chair is recused for some reason or has been the consulting board member. And then I think it would typically go to the vice chair. The pre-hearing conference is held by phone, and it's just the respondent and their attorney, if any, the prosecuting AAG, the board advisor, Kirsten, and the presiding officer. And it's really a scheduling conference to figure out how much time is needed for a hearing, how many witnesses are contemplated, which usually drives how much time is needed, how far out on the calendar it should be scheduled, and if parties intend to engage in discovery, which means quite a bit of additional time will be needed. And it's also a chance to explain, especially to pro se or unrepresented respondents, what the hearing process is about, what to expect, and what the issues really are for the hearing. And then afterwards, a pre-hearing order will be issued explaining all the deadlines and the time and location, unless that's to be determined, and then the subsequent order would be issued if the time and location still need to be determined. But a number of windows of time for a hearing will be collected at that conference from all the participants, because Christian will need to poll you as board members for your available times for matches, and hopefully we'll get some matches out of those in order to actually send out the notice of hearing.
And Bruce, I'd like to point out, the last year we've probably had, so as the board chair, I'm the presiding officer, we've probably had, I think, 3 of these that have actually gone to the pre-hearing conference. And again, it's really administrative. It's not really talk about the merits of the case. It's timing, deadlines, what scheduling works for everyone, and then every time the actual hearing's been canceled, because it's kind of encouraged people to settle, essentially sign the consent agreement.
Yeah, so you may, as board members, you may get a hearing set on your calendar, and then it settles, and you've seen this over the past year, and then you'll be told that it's canceled and you can take it off your calendar. But That's just often necessary in order to get these cases resolved. Next slide. So the participants, there's a quorum, obviously a quorum of the board is needed. The AAG advisor, the AAG prosecutor, executive director, and any staff that he wants to have included, respondent and their attorney, if any, witnesses for both parties. A court reporter is used to make the record in case of, and this is in case if appealed into the court system, and a transcript is needed at that point. And then the general public, because under the APA, hearings are open to the public. But however, the board deliberations after the hearing is closed, when they decide how to decide the case, are of course closed to the public and closed to the board staff and the prosecution team. The next slide. So defaults. So there's a 20-day time frame to respond to a statement of charges and request a hearing. So if there's no response or if it's late, that's a default. A motion for default will be presented to the board, and you've seen those by the email voting process, I believe. The board then issues an order which just imposes sanctions. But the respondent does have a second chance. They can move to vacate this default, but when they get those, it's a very short time frame. It's just 7 days, and there's supposed to show good cause for why they didn't show up at the hearing. But often, when in these situations, the arguments really will be about the merits and difficulty in figuring out sometimes what the good cause, if they're alleging any, is. So that sometimes those will come up. Next slide. So the hearing under the 3405 is the Administrative Procedure Act. As I said, a quorum of the board and the advisor, AAG, and then the presiding officer regulates proceedings, and the APA says to the extent necessary for full disclosure of relevant facts and issues, and must afford to all parties to respond, present evidence and argument, conduct cross-examination, and submit rebuttal. So it's like a mini trial. It's the same kind of structure, if you're familiar with that, but it's less formal, and the rules of evidence are relaxed. And next slide. There's a slide on evidence a little later on here, but it starts with opening statements. There's an opportunity for both sides to make opening statements about what they intend their presentation of facts and witnesses and testimony to show. And the prosecutor, the state, always has the burden of proving the facts that are alleged. So there's an order of direct examination of witnesses, and then the other side has an opportunity to cross-examine them. There's an opportunity for redirect examination and recross-examination. And then the respondent puts on their case second, or their attorney, to refute the charges, and there's an opportunity to repeat the order of testimony above. And the board, it's very important that the board ask any questions that they have of the witnesses while the witnesses are sworn in and testifying, because they won't have an opportunity to do that again. And if they have lingering questions with gaps in the facts, that can present a real problem at deliberation time. So the board has an important role in asking questions about anything that they don't understand or that they are not hearing being discussed. And then there's an opportunity for closing statements where both sides can sum up, what the evidence has shown and what they're asking the board to do. Next. So evidence under the Administrative Procedure Act, the presiding officer rules on any objections to admissibility, and they'd be assisted by their AAG. But evidence admissible evidence under the APA is evidence on which reasonably prudent people are accustomed to rely in conduct of their affairs. So it's quite a liberal standard, and hearsay actually is admissible like overheard statements of reporting what somebody else said. However, a case can't be based entirely on hearsay. That would be going too far. Evidence that's not admissible under the APA, evidence that's irrelevant, not material, repetitious, or in some cases privileged material, such as attorney-client privileged material. Usually, administrative hearing officers just err on the side of, especially if people are unrepresented, of letting almost everything in, unless it starts to become really burdensome and there's a lot of really irrelevant material. So next slide. So deliberation after the hearing is concluded, then in the closed session, usually right afterwards when everything's fresh in everybody's mind, the board deliberates, and based on the standard of evidence that must be proved by the state, in these cases is a preponderance of the evidence. So it's a more likely than not kind of standard. There's a higher standard of clear, cogent, and convincing evidence that the board could state that it also found, but it's not required under the case law to reach that higher standard. The decision, it's important to note that don't be based only on the evidence presented in the hearing. So this is a good illustration of why, as a board member, if you're going to hear a case, don't do any outside research. It's best if you know absolutely nothing about this set of facts or this respondent. And if you do, then you can always ask the board advisor if you should recuse yourself or not. If you have questions, just because you know somebody who's involved in the case doesn't necessarily mean you need to recuse yourself, but it's good to have that kind of discussion, because it's important not to find out at a later time that you should have recused yourself and maybe there was a bare quorum and it throws the whole proceeding into question. So, for instance, if you were a coworker with somebody who's now responded, that might not be a basis to recuse yourself. But if you were their supervisor, maybe they were your supervisor, that might be. So it's kind of, it really depends. So it's something you can talk to your advisor about. So the result of this is the advisor will draft findings of fact, conclusions of the law, and a final order imposing sanctions, and then circulate it among the board members by email for suggested edits and so forth until you reach agreement, and then you can provide the final one to Kirsten, who would then get the board chair's presiding officer's signature on it, and then would serve it by mail on all parties at the same time, including Charles. So there's the screening in place, and so all the parties receive copies of the board's decision at the same time. Next slide. So there's quite a flexible list of sanctions that the board can impose, from revocation to suspension, to the state suspension, to refuse to issue a license, or refuse to reinstate. Reprimands are available, fines up to $30,000 per violation. Investigative and legal costs can be imposed. Restitution, although that's usually not provided. Usually the parties are left to civil litigation between themselves if there are damages at stake in order to work that out through the court system. Conditions that are required before a license can be renewed sometimes. Next slide. Limitations on the practice are sometimes done, crafted by staff. Remedial education is frequently required. CP and ethics courses, other kinds of corrective action or practice monitoring or probationary type provisions. So your statute in the Accountancy Act gives you quite a flexibility about crafting remedial sanctions, because the purpose, I think, is to bring people into compliance and have good competent CPA practice. Next slide. So the final order, as I've said, signed and served. there is a provision that the respondent may ask for reconsideration within 10 days, but it's supposed to be based on errors, like clerical types errors and things like that. Sometimes they'll ask for reconsideration, but it's really an appeal. And if they're re-arguing the merits, it's more appropriate to go to judicial review. But that reconsideration could be something that the board receives and needs to act on with a final order on reconsideration as well. Next slide. So judicial review, the board order is the final agency action, and they have respondent who wishes to appeal has 30 days to file a notice of appeal in Superior Court. The judicial review would be based on the record compiled during the hearing. There's no new evidence allowed in court, so it's not. It's like an appeal. It's not a new fact finding. So it's very important that your record, your testimony, your evidence that's admitted be complete and support the board's final findings of fact and its sanctions, because that's all a court is going to have to look at if it has to review your actions. The standard of judicial review, what a court is supposed to do, is look at whether the board's order is supported by substantial evidence, as I've just said, and the test there is the evidence sufficient to persuade a fair-minded person of the truth proposition. And then finally, were there errors of law? And that's where the court does look at that de novo or afresh. It decides what the law. It can decide what the law is and disagree with what the board may have decided what the law is. But the board has really been the fact finder here, and the court doesn't have the ability to do new fact finding. Next slide. So compliance monitoring. This is for an area for maybe Charles to address. This is how orders are enforced. Did you want to say anything about this, Charles?
Sure. There is Kelly does run keeps a file of all board orders and anything that the respondent has been required to do to meet the terms of the board order, particularly with respect to CPE. They are required to report that, and we make sure that those conditions are met. And yes, that's definitely an element of follow-up on any investigative case or any disciplinary case, excuse me. Did you want to pick up executive director and staff review compliance with orders? That's Supreme Court's jurisdiction to enforce a board order converted to a judgment. So that's, this is an element of this whole thing.
Yeah, and that's something that's it's an option. It's rarely done. It's expensive, but it's a possibility to get enforcement of a board order through the Superior Court. Next slide. So in unlicensed practice cases, the executive director can again negotiate consent agreements or serve statements of charges. There's also an option for the prosecuting AG to seek an injunction in Superior Court under the Accountancy Act. And the executive director may refer cases, unlicensed practice cases, to the county prosecutor. However, I think the agency's experience with this is that the prosecutors generally are not really that interested in these cases, and they can refer them, but that doesn't mean the prosecutors need to go ahead with them. So the board can go with its administrative process and sanction these people. Next slide.
Bruce, I have a couple questions about formal hearings before we talk about. The question is, I've been on the board since 2016, and there's never been a formal hearing. And first off, this proves that we're able to structure consent agreements with people. This kind of proves that generally our discipline is appropriate, not punitive. But just the frequency, how long has it been since a formal hearing? I think there was one maybe about 10 years ago. Maybe?
I think there was one 9 years ago.
And how long was there one before that? Do we know?
Well, I don't know exactly how many years, but it wasn't that long before that.
Okay. My thoughts are, just throwing out ideas, we have the role of a consulting board member is sometimes a lonely role on an action, and now we're having CBMs involved in all actions, whether it's dismissed or not. And the reason we have CBMs not talking to other board members is to not to bias other board members and give the respondent adequate due process. But as far as a hearing, we only need 5 board members to have a quorum for a hearing, which we rarely have. We've got 9 board members, and so I'm wondering, in disciplinary actions, I'm just throwing out ideas, on ones that are investigated, could we use two CBMs? I mean, and that would help. I think sometimes, again, in the CBM, would have another board member to discuss the appropriateness of the consent agreement or whatever actions being taken. Again, so what I'm suggesting potentially, since board members are involved in all complaints, whether dismiss or not, on the ones that are not, where there's action to be taken, using another CBM to have 2 people kind of working, 2 board members working together on that specific case. Again, it kind of, I think it gives, it'd be more participation by the board members, and I think it would kind of reduce sometimes the questions a CBM has about, well, are these appropriate? I mean, they can discuss these with staff, but so I'm just wondering if there's any prohibition against doing that. I assume not.
No, there's no prohibition against doing that. It's just the need to ensure that you think you'll have a quorum eventually if needed. And I think there have been a number of cases where there were 2 board members recused for various reasons. Maybe there were successive CBMs for some reason or something like that anyway. And so it's just a matter of trying to ensure that you'll eventually have a quorum. But you have a fairly large board. I think you have that option where a lot of other smaller disciplinary boards would be too risky for them.
Okay, just a thought.
One other thought about that too, and Bruce has mentioned this in the past, that in certain cases where, say for instance, we go through the normal process of CBM is involved, we have a consent agreement that's being voted on by the board. We can hold a phone conference with the board members to vet any questions, is my understanding. So that might be one other option to sort of flesh out, to address the questions that board members may have regarding their anxieties about a particular consent agreement.
So essentially, when one is sent for, just talking out loud, so one is sent out for board vote, then board members could say, we could have board members say, well, maybe could we have a telephone conference to discuss this? And then we'd have a conference for any board members to have questions about it as a group.
Right.
Yeah, and that was something that I mentioned earlier when I was talking about consent agreements, that it's always an option for a board member receiving one of those emails to request that.
Mark, and we do that currently right now. If we get when we get questions back, that's when Kirsten will look at that. She'll bring it to Charles and say, this might be something we want to have a discussion amongst the board members, because too many people are having either the same question or just questions in general, so it must not be clear, that consent agreement.
Okay.
So we do that currently.
Okay, but that's a staff-driven, right, deciding to have it, rather than kind of board members saying, right, we'd like to have a discussion as a board about this.
Right, so that's why it's really important for all the board members. If you have concerns, don't just approve it. Please bring us back those questions. I think Charles and how he works this is we're open to anything. Don't just, staff says it's good to go. No, please go ahead and we need that, challenge and saying, hey, wait a minute, I have some questions. That's when we get those, then we can go ahead and pull the board members and have a discussion.
Bruce and Michelle, would that create a problem? Say, so a board member says, "Well, I'm really kind of uncomfortable with this. Could we have a discussion?" So the board members, other than the CBM, there's a telephone conversation, and them just making things up, and then the discussions fall apart, and then in the case there's no consent agreement signed, and then it moves on to a hearing. Has that discussion created a problem of having? Is the respondent going to have appropriate due process in that case?
Yeah, that's a good question to ask. Well, I would say that that board conference should observe the same screening as the board deliberation would have. So they could conference with their AAG advisor, and Kirsten as board clerk could be on the phone and discuss the appropriate outcome and questions they have and so forth. Because ultimately, if the consent agreement is somehow seems defective, they may just ultimately have to reject it. They can't rewrite it and go back to staff and have ex parte conversations about it, or they shouldn't be doing it that way.
Okay, so it'd be a more formal discussion, but again, it's not going to bias. It's not going to be seen as any type of. Obviously, we follow some procedures, but I assume it's biasing the board in case there's subsequently a formal hearing.
Oh, yeah, good question. So they reject the settlement, and then it comes before them for a hearing. But that happens. That's the normal course of these things. The board is the ultimate disciplinary authority. So if they disapprove a settlement, it'll come back to them for a hearing if it's not settled.
Okay, thank you.
So now we're going to talk about BAPS, Brief Adjudicative Proceedings. This is an alternative under the Administrative Procedure Act. All agencies who do disciplinary actions have this option, and many have opted to do it. They need to pass agency rules to authorize the agency to do it, which the Board of Accountancy has done in 4-30028. The rule lists the types of matters that are eligible for BAPs. Not everything is eligible for a BAP, because a BAP is a abbreviated type of proceeding without any witnesses or testimony or in-person hearing. It's just a record. It's like a record review. The evidence that's been collected by the investigative staff and any submissions that the respondent wants to put in are submitted to the BAP presiding officer, who reviews them. Well, there's been a staff decision that generates this, some kind of staff denial, and then that will be, a BAP, rights to a BAP will be given, BAP is requested, and then all that material that was used as the basis of the denial that's in the board files will be forwarded to the BAP presiding officer, who is one of the board members, for review, and to determine whether they agree or disagree with the staff action, whether they want to affirm it, deny it, and it's the result is just a letter decision. It's a pretty simple proceeding. It's not a detailed like a detailed order, but and then the BAP presiding officer is assisted by their AAG advisor, who will draft that for them and discuss the case, answer questions for them. And so these are the types of matters that they've been authorized by your rules: denial of a license, or denial of a renewal, denial of an application for reinstatement, or denial of an exam application. And next slide.
Excuse me, Bruce, can I ask a question?
Sure.
About the documentation that the board member would be reviewing. Is that documentation also provided to the CPA who is having the review process? I mean, are they aware of the same documentation that we're reviewing?
They should. Yeah, they should, and they're entitled to that. I'm not sure of staff's practice in, it should be documents that, I'm not sure if they're sent a copy of the full same material or if they have to actually request it.
Actually, so for the BAP process, we send them the letter that denies the application, so they have a copy of that. And within that letter, it states that they need to provide. So what usually happens is they will submit everything that they want to show to the board member. So they'll submit, and then we send a copy of the letter of the denial so the board member can review what was denied, and then they submit all of this documentation and forward it. They're the ones who provide you all the evidence to look at their denial and say, this is why I don't feel why I feel like the denial should be overturned. I disagree with staff, and here's the documentation that I'm providing.
Thank you, Jennifer. I think that for me was a missing link as to where is the documentation coming from? Who is providing?
They usually provide you a letter, and then the application, and then all the documents coming within the application. So I'll give you a general example. So we've denied somebody based on they didn't meet the education to sit for the exam. So they would submit all the documentation. You would look at that transcript and say, oh yeah, they don't meet the 150 hours to sit for the exam. That's why they were denied. And it's for you then to decide, do you agree with staff, or do you say, no, wait a minute, this person can't sit for the exam?
And remember, this is an appeal process. This is only people contesting that staff decision.
Yeah, I also want to make clear that their rights are pretty well communicated to them, and not only do they have the initial BAP review by a board member appointed as to do that, but there's a secondary one as well, so it can run past two board members in this process.
Yeah, that's the next step after the first BAP presiding officer issues this letter decision. The respondent is advised they may appeal that, but that's not to court yet, but to a second BAP officer. It's either the vice chair or designee under your rules that conducts a second administrative review, just the same procedure as the first review the records, whether they agree or disagree with the decision of the first BAP presiding officer, and then that actually becomes the agency final order. It could be appealed to Superior Court. And one thing that's important about BAPs to understand is that they can be converted to a full hearing at any stage, and either a decision of the BAP presiding officer could decide, hey, this really, there ought to be some witness testimony about this because there's not enough evidence here, or this may rely on witness testimony in order to determine it. So, and that has happened. I've seen that presiding officer say, I think this should be converted, and then we start that formal hearing process with set up a hearing conference and go down that track. Or the respondent can request it be converted to a full hearing because they want their full process. So just to be aware of that. Next slide. So this is about emergency action, immediate license suspension. Under the APA, there is an opportunity for agencies to take immediate action if only if there's an immediate danger to the public health, safety, or welfare that requires it. So it's pretty high standard. It's not just that it seems like it's a good idea, but there's a real reason why if some action isn't taken to suspend the CPA's license, that the public will be injured, and in the meantime, in the few months before a hearing would take place. And so they're used rarely, but the board would issue an order that's effective immediately with findings of fact, conclusions of law, and reasons for why this is an emergency. And so then there's an option for an expedited hearing, which may be kind of challenging to set up. There's nothing in the APA that has a time frame for that, but it's good to try to set it up within the month, if possible, and get everybody's schedules aligned to do that. And then there's an opportunity to contest whether there's an emergency or not, whether the suspension should have been immediate. And that could be combined with the hearing on the merits, or the hearing on the merits could be scheduled at a later date. So that's the process for those types of cases. Next slide. Yeah, I think I've discussed this already about the need to justify the emergency. Because they're not, and this is because they're not given a prior hearing before the state makes them adverse action against them. Normal requirement of due process. Next slide. Okay, general precautions for all adjudications. Next slide. And this is just about screening again. We've already talked about this to avoid ex parte communications between respondents or prosecution staff and board members before they've decided a case about a pending action. We need to keep in mind that the two opposing teams, as it were, and that they are not having any discussions. And that mention of between respondent or board prosecution staff on the one side and the board on the other side, that's is a reference to other board members other than the consulting board member, because the consulting board member would be on the prosecution staff side.
Bruce, could that, if there's approach to any single board member, would that trigger any one of the 9 other than the CBM? Would that trigger that communication requirement?
Yeah, it would. If that happened, it would be something you'd want to talk to your advisor about, whether the level of it was concerning or not. But it can be mitigated if somebody approaches you and wants to talk about a case. You can just tell them, I can't discuss that with you, and that, you could report the approach, but you wouldn't need to recuse yourself if that was all that happened. But if something more than that happened, you didn't realize that you'd been in a 45-minute discussion with somebody about a case that was going before you, it could be that, then maybe you might want to consider recusing yourself. But it's a good thing to discuss with your advisor. And then, it's important not to discuss cases that you're aware of coming before you with anybody other than other board members who are going to hear the case, and not to do, as I mentioned before, any kind of outside research. Avoid if it's on the news, try to avoid hearing or reading that news story. You may not know that that's going to result in a case later on, and if you did see a story, it might not be enough to end up recusing yourself because you'd seen a news story. But just something to be aware of. Is there another slide, or is that the end? All right. Anybody have questions?
Just one observation for everyone, and we'll have a question and answer period, and then we'll take a break. The BAP hearings, there's been 2 BAP hearings in the last year. I did them both. They're both a staff denial of a license application. It was pretty easy process. It was review of documents. The plan is I'm going to start a tradition, or the chair spreading the BAP hearings around board members. So everyone will get a chance in the next, hopefully during the term on the board, to act as a presiding officer for a BAP hearing. So if you have any questions about those hearings, and we'll talk when Taylor talks his presentation, CPE deficiencies are now going to be routed through the BAP process. So there'll just be more BAP hearings as well. But other questions? We had other questions, and then we have a question from the audience. Let's have the board, questions from the board, and then we'll make sure we get to the questions from the audience. Any questions from the board? Okay. If not, Ken, you have a question.
Yes, thank you very much for being recognized. The question relates to slide 50, the one that says scope of authority. And the question is, if someone has a complaint against an entity who's engaging in the practice of public accountancy, and the Board of Accountancy chooses not to engage in that, I guess the question is, it seems like it's a dead end, and particularly this relates to the state auditor, which does over 2,000 audits. So the board, I don't believe, has discussed this. I've been asking the same kind of question for about a year. So is it clear that the State Board of Accountancy's position is that there's no path, or there is a path in terms of a question about an audit done by the state auditor?
this, and it's clear we don't have jurisdiction over that, so the path of that complaint would be to the agency that has jurisdiction over that person, which would be, for example, in that case, like the state auditor's office.
Okay.
We have clearly determined and exhaustively looked into it that we just don't have jurisdiction.
With respect, Chair Hugh, the board has not discussed this. It has been a decision by the executive director and comments from you, but the board as a whole has not discussed it to my knowledge in the last year. I've been watching the meetings, and the board has not asked for clarity and to dug into that. There is not a written documentation from the Attorney General's office or Attorney General opinion letter on this in the conundrum. That'll be part of my comments, but I just wanted to make sure here, and it's more at this point a transparency out to the public and to the other members of the board that state auditor audits, you guys don't take any, there's no path to relief through you for audits by the state auditor's office.
Well, thank you, Ken, for your comments, and you'll have comments later on. Mm-hmm. But again, it's been addressed at board meetings, and it's been determined that we don't need to have a long, extended discussion at a board meeting over something we don't have jurisdiction over. But again, you'll have an opportunity at the end of this meeting to make further comments.
Thank you for being recognized. I do appreciate that.
Other comments from the board? Okay, if that, let's take. Go ahead.
Sorry, there's one question in the chat from Scott. He says he has a question.
Yes. Oh, Scott, please. Yeah.
Question about the collection of monetary amounts and consent agreements. If you
Scott, would you just like to ask your question?
I would. Thank you for being recognized. I teach a board-approved ethics course and have for about 15 years now. And I use the consent agreements, especially the current ones, as a way to illustrate ways in which CPAs can run afoul of the board's rules. One of the most common questions I get is in looking at the different methods that the board has for putting things in the consent agreements is people ask whether the board collects on the amounts that are included in the consent agreements, especially the very large ones, which are anywhere from $5,000 to $30,000. So, if you don't mind, would you mind discussing the board's enforcement or collection activities as it relates to those?
I'm happy to speak to that. This is Charles Satterland. Yes, Scott, we do collect on the fees, that are stipulated in consent agreements or board orders, depending on what's happening. In the case of a default order, where a person is sort of skipped town, they're not responding to anything that we're doing, there are often monetary amounts that we probably will not collect due to the fact the person's a non-cooperation. Those, and I apologize for the noise, in those instances, we do turn it over to the collection agency. We have recently implemented that practice, and we will make the attempt to collect that, but we may not always be successful. Secondarily, there are some cases where we will revoke a license, attach a large fine that is contingent to be paid upon the person's reapplication as a CPA. I hope that answers your question.
It does. Thank you very much.
Okay, with that, and no further questions, I have it's 10:49, so let's take a 10-minute break. Let's take a 10-minute break, 11-minute break, and come back at 11 o'clock, and then we'll resume the rest of our board meeting.